Well, hundreds of thousands of Idahoans are preparing for a new relationship with their employers. The Federal Trade Commission voted just this week to ban non-compete agreements, contract clause that some states, including Idaho, have upheld for decades. And Andrew Bartline dug into this today for us. A lot of interest in this. And Andrew, you learned the scope in the gem state is actually bigger than originally anticipated.
Yeah, it's bigger than we originally understood it to be. So the FTC estimates that there's 600,000 Idahoans that are bound by some form of a non-compete agreement. You can argue on whether you believe that is accurate or not, but that's what they have in their documents. And in simple terms, it's a contract clause that prevents an employee from taking a different job with a competing company. These non-competes can be enforced up to a year and a half after an employee leaves work with that original company. The FTC argues this keeps worker wages down, and overall it creates a business system that mostly benefits corporations and employers over consumers and employees. Banning the agreements could be a big shift in Idaho's job economy, but it will take some time before anything is final.
This rule doesn't go into effect for 120 days from yesterday. And that's assuming that it won't be stayed in the courts, which it's largely anticipated that that will happen. The FTC authority is being directly challenged already because, frankly, we knew this was coming. The U.S. Chamber of Commerce was primed to file that lawsuit in the Eastern District of Texas. But if you are a business that largely uses non-competes, you can be thinking ahead to what you're going to have to do under this rule. It requires you to give a notice to any employee who's currently under a non-compete that it won't be enforced.
Now, that's Alex Grandy. She's an attorney here in Idaho specializing in the field. She says she's spending most of her day explaining to her clients that being a business who relies on non-competes, what they should or shouldn't be doing. That includes that notification process. Grandy adds the rule does not include senior executives that make policy decisions for their companies and pull in large six-figure salaries. Now, that cap is at about $150,000 a year. People above that, this wouldn't apply to them. Corporations like those non-competes because it protects them, though the FTC says there are less harmful ways, I should say, that can preserve those same protections.
What they think employers should be using are NDAs, narrowly tailored non-solicitation agreements, and common law trade secret protections that exist in almost every state. At some level, they think that's sufficient and that you don't need to restrict an employee from compete with a non-compete. But other businesses use them to protect what they would call their legitimate business interest. But for folks at lower level positions in the company who feel, what do I know about the company? What trade secrets or confidential information do I have? I shouldn't be subject to a non-compete. I think that's a pretty common refrain.
For now, Grandy says this is a game of hurry up and wait. She mentioned legal challenges from the U.S. Chamber of Commerce could result in a stay to pause that temporarily, that rule. That would put that new FTC rule on pause, though currently the 120-day countdown to when it would normally take effect, that is business as normal. There are roughly 30 million Americans, Joe, that are bound by some form of non-compete, and it would change the landscape across the country for states that allow it. Washington, not so much more recently. California hasn't been a fan of these for a long time, but that relationship would change because traditionally, hey, we'll relocate you to the area, you can work for us, but once you're done working here, you cannot compete in this town with another company that competes with us.
And it's interesting because those that are in support of it say this is about job creation and they want to have more creativity in that entire, fields across the country. But you can understand, too, from the employer's perspective that if Andrew, the employee, has secrets, I don't want him to go to my competitor and, well, I'll do my business. So a lot to weigh here for the courts. Well, when they get to the courts.
Yeah, and there is a challenge in Texas. We'll see if there's an injunction, if there is a stay. But again, hurry up and wait's the game right now.
Okay, well, we will hurry up and wait. Thank you so much.